Restraint of trade is a critical concept in business law that affects competition, free trade, and business operations. This video will explore the key aspects of restraint of trade, including its types, legal implications, and remedies. Restraint of trade refers to any activity that unfairly restricts competition, limits free trade, or hinders business operations. It covers a broad range of activities that interfere with someone's ability to conduct business freely. These can include creating monopolies, coercing others to stop doing business, fixing prices, or using contract provisions like non-compete clauses to prevent competition. There are several key types of restraint of trade. Non-compete agreements restrict employees or business sellers from competing within a specific area or time frame. Exclusive dealing agreements require a buyer to purchase solely from one seller. Price fixing occurs when competitors agree to set prices, harming consumers. Market division involves businesses allocating customers or territories among themselves. Tying arrangements force customers to buy additional products or services along with a desired item. The legal framework governing restraint of trade is primarily based on antitrust laws. The Sherman Antitrust Act of 1890 makes it illegal to participate in unreasonable economic restraints. The Clayton Act and Federal Trade Commission Act also play crucial roles in regulating trade restraints. Courts typically use two main approaches to evaluate these practices: the per se illegality test for inherently anti-competitive actions, and the rule of reason test, which weighs the restraint's legitimate purposes against its anti-competitive effects. It's important to note that not all restraints of trade are illegal. Reasonable restraints that serve legitimate business interests and do not harm public interest can be valid. For example, a manufacturer agreeing with distributors to serve defined territories can be considered reasonable. Non-competition agreements and employment contracts can also be acceptable if they are limited in scope, duration, and geography. When a restraint of trade is found unlawful, several remedies are available. Courts may issue injunctions to prevent further violations. Victims can recover monetary damages for economic harm caused by the restraint. Government agencies can impose fines or sanctions against violators, particularly in antitrust cases. In conclusion, restraint of trade is a complex area of business law that significantly impacts market competition and business practices. Understanding the key types, legal standards, and potential consequences of trade restraints is crucial for businesses to operate within the bounds of the law and maintain fair competition. By balancing legitimate business interests with the principles of free trade, the legal system aims to foster a competitive and equitable business environment.